It's an application, the application for leave to appeal of Legoabe, Willie, Seriti, and Hendrick, Mmolli, Musi, both in their official capacities versus Corruption Watch and the Right to Know campaign, as it pleases the court.
Thank you very much, Nolin. Advocate Nalane.
May it please the court, my lords, my lady, I appear on behalf of the first and second applicants together with my learned friend, Advocate N. Mayet.
Thank you, Advocate Nalane. Advocate Butlander.
May it please the court, I appear on behalf of the first and second respondents with my learned friend, Mr. Khoza.
Thank you very much, Advocate Butlander. The first issue that I think we need to place on record is the application for leave to file the President's explanatory affidavit in the constitutional challenge application brought by the current applicants in a different application. But the leave is sought to introduce that affidavit in this matter. What is your attitude to the application, Advocate Nalane?
We are not opposed to the application to admit that affidavit.
Thank you very much. Advocate Butlander, any submissions on your side about this? Or do you leave it as?
Respectfully ask that the application be granted and the affidavit be admitted. It has been answered by the respondents, by present applicants, and it's relevant because it explains the circumstances under which the present applicants elected to abide the decision of this court in the review application.
Thank you very much. Leave is granted for the President's explanatory affidavit to be admitted in these proceedings. The costs of that application will be costs in the course. As agreed, Advocate Nalane, the clock starts ticking now for you to start submitting making your submissions. You have an hour, but the first 15 minutes of that hour, the court will not be posing any questions to you. Please go ahead.
Thank you, my lords, my lady. This is an application for leave to appeal by two retired judges who, in the twilight of their years of retirement, have now to face a inquiry of judicial misconduct flowing largely out of this judgment, which is the subject matter of this appeal. We will address the following topics. First, the condonation application. Secondly, preemption. And then thirdly, prospects of success. It is common cause that this judgment was delivered 2 years ago, and only now in 2022 do the applicants seek leave to appeal. What we would submit that the trigger time and where the calculation of the time periods for the leave to appeal and accordingly whether condonation should be granted is when the judicial complaint was laid against the two applicants in May of 2021. Before then, the applicants tell the court that, like any other tribunal or any other judge, decisions get overturned on appeal or on review. And because they were not personally involved in the matter, they were not personal litigants in the matter, and were merely reviewed in their official capacity as functionaries who were performing a public service of chairing a commission of inquiry, they did not have any particular personal interest in the matter to the extent that they would have required or had a need to enter the fray and take the matter on appeal. The matter has now taken a new turn and that the same judgment which they were content to live with, like any other judge who gets overturned on appeal or review, it is now being used to lay charges of judicial misconduct against them, to the extent that even in those allegations, in the charges, there are allegations of corruption and fraud and criminality. Of corruption and criminality, not fraud. And so the matter has now assumed a personal tone. When the Judicial Services Conduct matter started, the complaint was based almost to the letter on the criticisms which this court laid against them in the judgment, in that they did not conduct themselves properly as judges should have, and simply because this court has found that on the view of the applicants, of the respondents, I'll call them respondents, this is the two organizations, Corruption Watch and Right to Know, which essentially have been driving this application. So would submit that the timeline should start in May 2021. Then we should ask ourselves, what is it that the applicants did to bring this matter to the court? And the reason they explain is that when they sit in the Judicial Service Conduct Committee, the facts and findings of the court are there. They are in the form of a judgment. And this judgment is being used by the respondents to say, this is a finding of a court of law, and this finding, therefore, must mean that the final finding. And they would be hard-pressed in the Judicial Service Conduct Committee to say, the court erred in this or in that respect, so they will be told, but you didn't appeal. And so that is why it is important for them to then come to the court and seek to challenge the judgment. First and foremost, they explain in the affidavit that they had to deal with the Judicial Service Conduct matter, and then thereafter they focused their mind on this issue. And one of the reasons why the matter took long to come to court, even after the service of the complaint against them, is because the court file was not available. And it was made available much, even when they filed the application, the court file was not yet available. Would submit that they took action as soon as they were able to, within the reasonable time to bring the matter to court. And so would submit that a good case has been made for condonation. And as the court would know, one of the principal standards is whether it will be in the interest of justice. We submit that it is in the interest of justice that condonation be granted. And this concept, this issue of interest of justice, we submit flows through the entire application. It will also touch on the prospects and the preemption as well. And we submit that this is a matter of particular importance to these parties. The respondents, on the other hand, do not have a personal involvement or a personal interest in the matter per se. They are civil organizations which came to court in the public interest. So they are not personally invested in the judgment per se. It is not as if they'll be deprived of money or some other relief if the application for leave to appeal is heard. I see Justice Mlambo is not on the screen.
I'm here, don't worry. I'm here.
So would would submit that one must weigh the interests of both parties, say which one should take more precedence in the circumstances of this matter. We're not dealing here with the typical litigation of a party seeking either delictual or contractual relief against the other. We're dealing with people who are doing a civil service, and in the process, they are now being accused of very serious allegations against them. So we submit that on the papers the applicants have made a case for condonation, and the case law and the legal principles, I think, are quite clear, and we have also set them out in our heads of argument. The next point is preemption. It is a matter of common cause that the applicants chose to abide the decision of the court. But again, one must look at the peculiarity of the parties. There were 7 judges at the time. The state attorney was seized with the matter. The state attorney defended the matter, and the other parties, particularly the president, at whose behest the commission was put in place, also was defending the matter. Now, a sitting judge who has made the report, this report is for the benefit of the President of the Republic of South Africa. The President is seized with the report and has got a variety of choices. Can either accept or reject the report. And so when the matter starts, the President enters the fray, defends the matter. At some point, the President then withdraws their opposition to the matter. Now, what would a litigant who is cited in a nominal officio capacity, who's a sitting judge, what is expected of a litigant of that nature? The litigant says, well, I will abide. The report which we have produced will speak for itself. One could say, well, they could have filed an affidavit explaining their side, but that would not have taken the matter much further, because the report is supposed to speak for itself. You can't make a new report on the report. And so they were reasonably expected, and they exercised a reasonable choice of abiding by the decision and choosing not to challenge or oppose the matter. Now, the question is whether in those circumstances, must the door of justice be closed in their face when circumstances have radically changed and when the same judgment is now being used as a sword to attack them in a judicial misconduct matter? Our submission is that the interest of justice should not operate to bar a litigant such as the applicants who were doing civil service, who are now in the twilight of their years as retired judges, and who now have to face this judgment, which is really a sword which is being used against them. We submit that there are prospects of success, even on the preemption point, because the preemption, as I understand it, is not an absolute bar to a party who even has chosen to abide by a judgment or order. It is not an absolute bar. And the Constitutional Court has also said as much, that the touchstone is the interest of justice. So we would submit that the facts in this case are quite peculiar, because one can ask the question, while the applicants were still serving as judges, and soon after the judgment came out in 2019, why did the respondents have to wait for 2 years and only then lay this judicial misconduct matter when the judges are no longer in active service. And so the events and train of events which have occurred are not as a result of the conduct of the applicants. It's beyond their control, but would submit that the doors of justice should not be thrown, and they should not be disadvantaged by being denied justice, especially, as we have said, because of the peculiarity of this matter. We have cited the relevant case law in our heads of argument. We do not need to repeat them, but would submit that this is a case in which the interests of justice should prevail and the applicants be allowed to challenge the judgment. The next issue is the prospects of success. Again, the interest of justice is a common feature which also comes into this matter. But at the outset, the review court recognized that this matter raises novel issues, and there is no readily available authority or jurisprudence in our country to shed light on how to deal with matters of this nature. And that's why the court had to borrow from other jurisdictions, New Zealand, Canada, and apply those learnings to our situation. We submit that that is one of the considerations which must be taken into account, that the law is not settled as far as the review of commissions of inquiry are concerned. It is a matter of great importance, not only to the applicants who were sitting in an official... Yes, JP, it's my 15 minutes over. Let me, I'm going to...
Your 15 minutes is over, but there's something, I don't know if I'm the only one. I seem to be losing some of your submissions, so whether it's my connection, I don't know. But yes, your 15 minutes is up, and the bench will start posing questions at you.
Can I ask for just 1 minute, just to round off the prospects of success?
Yes.
Yes, just 1 minute with the indulgence. One of the questions is whether a court of law can review a commission of inquiry on the basis that that commission did not act as a reasonable commission should have acted. And we submit that there are prospects that another court can come to a different conclusion in the circumstances of this matter, and that the test of rationality as far as the commission of inquiry, especially this commission of inquiry, is something which should not be applicable in this case. The commission chooses when to sit, where to sit, which witnesses to call, how to conduct an investigation, and that is not something which we submit should be reviewed. The commission's reports are not binding on anyone. They don't have any external effect. The president can throw the commission report into the dustbin, not look at it again. And so it serves really no purpose to review a fact-finding entity or exercise like that of a commission of inquiry. And we submit that this is a matter of great importance, which should be taken on appeal. And finally, even if this court does not agree that there are prospects, the test as well is whether this is a matter of sufficient public importance. We'll submit that on the basis of the Hlophe judgment, where JP Hlophe was granted leave to appeal, even though the court said we do not think that there are prospects of success. Matters of judges and their discipline, especially where they sit in commission of inquiry, is a matter of great importance. We submit that there are good prospects.
Mr. Nalane, am I correct to understand your client's stance, especially the preemption part, that they abided the decision of the review court.
Yes.
And in full awareness of their rights. And what changed is this complaint of judicial misconduct.
Sorry, I'm having trouble with the connection. Try again in a
Yes, JP Mlambo. That is the factor which changed their stance on the judgment.
But that's what I wanted to explore with you. I mean, is it your client's case that the judgment that they now seek leave to appeal against made judicial misconduct findings against them? Because that complaint is a complaint of judicial misconduct. Is that their case?
No, my lord, they're not saying that this court made findings of judicial misconduct on their part. Far from it. What they are saying is that the court made certain findings of fact, which it accepted, and so that the judgment will be binding on all and sundry. The same factual matrix which underlies the judgment, and the judgment itself is being used as a form of judicial misconduct. But in order for them to deal with this new development of judicial misconduct, they've had to look at the judgment again. And clearly, the judgment prejudices them quite substantially because of the findings which must be accepted.
Yes. But Advocate Nalane, I mean, judges, especially first instance judges, are criticized on a daily basis in terms of the judges that they make that go on appeal. And that criticism has nothing to do with any misconduct on their part. It has to do with how they dealt with the matter, how they dealt with the law, and how they arrived at their conclusions. That's got nothing to do with misconduct. So I'm battling with understanding why a judgment that has nothing to do with misconduct on their part, especially the misconduct that is alleged in the complaint, that this judgment has nothing to do with that and said nothing about the judges having misconducted themselves in that manner. And I'm battling with understanding why should such a judgment, which is self-standing and has nothing to do with that process, how can it be used as a basis to say, no, we think we've changed our minds, we want to leave to appeal against this judgment because it's being used against us?
Well, the first point they're making is that they've always disagreed with the judgment. They've never thought it was correct in the first place.
Yes.
And so it is not as if they've now changed their mind to think the judgment is great. They still think it's wrongly decided.
Yeah.
And now that this judgment is being used against them, and the complaint is based completely letter for letter on the judgment. It says that what you did in the running of the commission of inquiry, as found by the judge, as found by the court, that amounts to misconduct. This court, of course, does not have to decide whether it's misconduct or not. Neither does the appeal court. But the personal interest of the applicants would be served much, much better. This has got to do with interest of justice, would submit. Their interest would be served much, much better if this judgment is revisited and taken on appeal. That's our submission.
Can I ask you, So can I ask you, Mr. Mmolli, I suppose what I'm struggling with, following on the Judge President's question, is would you agree with me, and of course you don't have to, that the Judicial Service Commission, when there is a complaint, would have to deal with that complaint, as it were, on its own terms? In other words, they couldn't simply say, well, here's a judgment, and therefore, because of that judgment, your clients are guilty of misconduct. Indeed, the two are totally separate inquiries. The inquiry before the Judicial Service Commission, presumably, would have to be a proper hearing, assuming it went ahead, in which a whole range of issues would be raised, dealing pertinently with whether, in fact, the judges in question committed gross misconduct. That's an entirely different question, surely, to the question of whether, in fact, one sets aside a commission of inquiry because of, let's say, procedural or other irregularities.
Justice Davis is correct to say that the inquiry in the Judicial Service Commission will have to start on a different footing, yes. However, it cannot be ignored that this judgment is being used as the basis for the complaint. The complaint says you did not probe witnesses. You did not ask proper questions. You derelicted your duties as judges in conducting that commission of inquiry. And therefore, the standard of conduct which you exhibited throughout the commission of inquiry is one that cannot be expected of a judge. And that constitutes misconduct.
But that would have to be, sorry to interrupt you, and let me just apologize immediately. I always find with this particular medium, it's so hard to know when to jump in. So I'm not being rude or disrespectful if I interrupt you. Mr. Mmolli, but I suppose the question for me then is this. I understand your argument would basically run along the following lines. The judgment that the three of us penned has been used on your line of argument to generate a complaint. If the judgment went to the court to review the commission of inquiry, but in fact, that can't possibly have been the real answer, because really, as you've emphasized, this entire basis of the condemnation is brought on one central basis, which is, well, if there hadn't been a complaint before the Judicial Service Commission, my clients would have left this alone, notwithstanding the interesting legal questions that arise. So would I be right in saying we would have to decide on condemnation on the basis that the judgment that we have penned actually has an important implication for your clients because of the complaint? And that's the essence of the issue. That would be the reason for granting condemnation.
That would be the important consideration, yes, for the for the applicants. And then and in saying yes, it's an important issue which affects the interests of these applicants. The court will then have to delve further and into the judgment itself. And coming back to your remark, Justice, earlier, that perhaps one way of looking at it is that the applicants are saying, if the judgment goes away, the complaint might go away. That might well be the case. That well might be the case because the complaint is anchored on how they conducted themselves in the commission of inquiry and how they were then overturned by this court. So that is a very important part of the complaint against them. And if the judgment is well, generous to us, if we succeed on appeal, yes, that might well be the end of the complaint. And then a new complaint might arise, and then we'll see it when it comes. But this complaint is centered around the judgment.
Well, not necessarily, you see, because let us assume for the purpose of debate that you go on appeal and your main point, which is, well, they didn't, that court's powers of reviewing a commission of inquiry are narrower than this court decided. But let's assume that, because you've made an emphasis. because you've referred us to comparative authority suggesting not so fast. The jurisprudence may not be entirely supportive of the approach that this court took to review. That would leave intact, would leave basically without any comment what we had decided in relation to the, let's say, the manner in which the commission was run. And that would therefore follow that a complaint which is lodged would continue, as it perhaps would in any event, on the basis that the JSC would then have to decide whether, in fact, the manner in which the commission was conducted was such as to amount to gross misconduct, which, as I keep on saying, would be an entirely different test. So it's not necessary, does not necessarily follow at all that this judgment goes away, so does the complaint. And as I say, you seem to be hitching your your wagon to the complaint horse, as it were, because without the complaint we wouldn't be here. That's why I'm putting these points to you.
Indeed, Justice, what if there is a possibility, which we say it's quite immense, that if we are successful on appeal, the complaint might go away, or should go away in a large measure. The complaint is packed on the judgment. Without the judgment, the respondents will not have complained against the applicants. And
Can I make a follow-up on this issue?
Yes, Justice.
What I don't understand is the very same issues that you are raising against this judgment. And according to the applicants, the complaint is solely based on this judgment of this court. The very same issues that you raise here for the purpose of condonation, you can as well raise them there at the JCC. In other words, if they are relying solely on what is in the judgment, can't you raise the very same issue at the Judicial Conduct Committee and say that particular court erred as in respect of the following? Why should a long way of going first through the appeal court and not attack this judgment where it is used for the purpose of substantiating their complaint?
Could I just add to that when you give your answer? It goes back to the earlier point that I made, but I'm indebted to my sister for putting the point the way she did, which is this. If the Judicial Conduct Tribunal said, oh, well, there's a judgment of 3 judges, that's what we don't have to do very much more. It seems to me that would be completely improper and wrong. And precisely because the judgment would actually not be binding in any way on them, and precisely because a tribunal would have to trawl through all the evidence to make its own personal determination on the question of a different test, namely, did these judges commit gross misconduct sufficient perhaps to have them impeached? It's precisely because of that the question that my sister puts to you is so pertinent.
As far as making the point to the Judicial Conduct Committee and saying, well, this court erred in this or that way, the Judicial Conduct Committee is simply a committee. So there's nothing that they can do to overturn a finding, even if they might disagree with it. Only an appeal court can really, as far as applicants are concerned, can really vindicate them, and so it is called comfort to say, well, go to the Judicial Service Conduct Committee. The judgment is not binding on them, and see how you go there. We'll submit that a better justice-based remedy, which takes into account the personal interests of the parties and interests of justice, is for the matter to go to a higher court. And we say that it also raises other interests and other matters, which, although they might not be related to the parties directly in the conduct, but they are matters of importance, as the court said in And that's as far as I can take there. But as far as the other issues are concerned, that this court must look at is, although there might be issues of a personal nature, if I may put it that way, which personally affect the applicants, there are other public interest issues which the appeal application raises, which would submit that should be dealt with in an appeal court. These are some of the following reasons. To what extent, what is the scope of review of a commission of inquiry, where the commissioners come to this or that view? Can a court of law such as it is done in this matter set aside the entire commission report simply because of one or two complaints which go to how the commission conducted themselves as a commission and made certain choices about which witnesses to call, and so we submit that the personal interest of the applicants in the matter should not be the only abiding factor which is taken into account, that there are other public interest matters which are implicated by this judgment.
You see, before you get there, just let me just close off my final question from my side in relation to the exchange you've just had with myself and Judge President Liu. It does appear to me that when we start talking about what is the basis for the leave, it's far less about the interest of justice and far more about the personal interests of your clients. I'm not suggesting that's entirely wrong, but all I'm suggesting to you is that the thrust of your argument is that the broad interests of justice were not really in their mind at the time that the review application was brought, nor at the time of the hearing. And in fact, almost all of the exchange that you've had with the bench has been to say this particular judgment has material bearing on the personal interest of judges, of the two judges. I mean, we can't get away from it. It seems to me that, to sort of say, oh, well, and apart from that, there's this very broad issue of interest of justice. It does seem to me that what we've got to really make a determination on is justifying condemnation on the basis of the personal interest of the judges.
I would submit that one should not look at it as narrowly as only the personal interest of these two judges. They do make the point in their papers that there are implications for other judges as well who would sit in commissions of inquiry in future, and how commissions of inquiry should be dealt with by the courts. So I would submit that public as well as personal interests might coincide, but it does not mean that one must overlook the public interest simply because there are personal interests as well.
I would have been, sorry, Mr. Mmolli, for interrupting you, I would have been a lot more persuaded had they in fact opposed the application from the beginning on the basis of saying, goodness gracious, this is very important, because if these three judges poke their nose into our business, who knows what other judges might do with other commissions? But that didn't happen. And the only reason that we're here is because of the complaint which has been generated to the JSC.
I have dealt with the reasons why they didn't oppose, and they've
okay,
done
that's fine.
And the involvement of the state attorney, presidency, and then they withdrew at some point, and the limitations of resources as well as what more they could possibly do.
Okay.
But those issues remain alive. They cannot be ignored simply because there might be personal interest. In all matters where parties go to court and say it's in the public interest, in many instances is because they are first and foremost personally affected. But of course, the issues that affect them personally raise constitutional and public interest matters as well. I'm thinking here of the Constitutional Court judgment, which involved a party who was dismissed, and for a long time, and the Toyota case, and so might be wrong there. But the point of the matter is this party, who was dismissed and did not come to court as early as he could, applied for condonation. The court said, we'll take into account the circumstances of this party. He's indigent and all that. But in any event, his personal case raises issues of public importance. It's like Judge President Hlophe. He's appealing. It's a matter which involves him. But the court has said, this is not simply about him if you look at it in the bigger scheme of things. It impacts on the judiciary. It impacts on the integrity of the judiciary, administration of justice. And so all those factors must be prominent and be taken into account and not be simply swept aside.
Okay, fair enough. I understand that argument.
Can
I then just ask you, because I don't want to take up much more of your time, but am I right in saying you did move into dealing with questions of prospects of success, as I understand it, by suggesting that, well, you can't nitpick and take a couple of mistakes that a judicial commission would have made in order to justify a review. Now, I understand that your line, but with respect, it does seem to me when one reads, as I reread the judgment for the purposes of this hearing, that we mention a whole vast range of issues that you haven't even touched upon. I'll give you a few examples. I'm probably going to pronounce it wrongly, but it's a Debevois and Plimpton report. There's the whole issue of Mr. Shlongwane. There's the aspect of the Mutual Assistance Act. There's the whole question of whether, in fact, Dr. Young was dealt with correctly, etc., etc. In other words, if a judgment finds a whole string of, let's say, inexplicable irregularities, it's not a question of one or two. You read it and you say to yourself, but there's so many unexplained problems here, some of which you haven't even touched upon in your heads of argument for whatever reason. And surely you've got to then say, in terms of prospects of success, well, it's no good telling us about 35,000 pages, not even good at all. You've got to sort of persuade that their prospects of success, because the whole range of findings upon which this court found that, in fact, the commission had to be set aside, it's not just a couple of small details. These are fundamental questions to the very inquiry which the commission was mandated to undertake. I'd appreciate your response to that.
I would submit what cuts across all those complaints, individually and collectively, is the following. This is a fact-finding commission. It happens to be chaired by two judges. And assuming, as the court did, that the commission should have made sure that Mr. Shlongwane is asked a few more vigorous questions.
Any questions?
And well,
any.
Let's assume he was not asked any questions at all.
He wasn't.
Let's assume he was not asked any question at all. But is that the terrain of this court to say to the commissioners, you should have asked this or that question, or should have pressed them on this or that issue? And that's precisely where we say that there are prospects. The commission report is meant for the President of the Republic of South Africa. It is not binding on anyone. Whether this court agrees or disagrees with how the commission went about its business, the court might well disagree. The whole nation might well disagree that maybe they should have probed more, they should have probed less. But they are not they're not exercising administrative action which is subject to review. They exercise a discretion as a commission. The court found at paragraph 18, 1.9-11, summarizing what the complaints of the applicants. It says the applicant's case is essentially the following. The commission failed to gather relevant material. I would submit that even if that might be factually so, which is not in our view because of other parts of the record, even if they fail to gather relevant material, that is not a reviewable conduct. Even if they didn't properly...
Sorry to interrupt you. Are you seriously submitting that if, for example, you've got very crucial witnesses like Mr. Fongwani and Mr. Chippy Sheikh, who are absolutely central to the entire arms deal. Mr. Shongwani doesn't get asked one question. Mr. Sheikh doesn't get asked questions about whether he solicited a bribe, extensive involvement in decisions which that were found by the draft auditor's general report to be in violation of good procurement practice, etc., etc. And then you take that and you say they don't deal with the Devoir report. There's a complete misjudgment of what constitutes privilege on any elementary reading. There is the question of why, in fact, the Mutual Assistance Act isn't invoked, a totally unsatisfactory explanations, and I can go on and on and on. Are you seriously suggesting that that means that their prospects of success that this commission was run as a commission is intended to be? Which is basically what on prospects of success one would come to, saying actually this court got it horribly wrong. In fact, the commission was run according to proper, as it were, commission lines, if I could put it that way, in a proper inquiry to determine facts.
The judges tell the court, even in their commission report, how they went about dealing with the investigations. They had policemen and Mr. Deploy. They had forensic investigators. And the commission was conducted in public for all of us to see. Anybody else could have cross-examined any of the witnesses. So the fact that they didn't ask this or that question, or didn't probe as deeply as some of us would have wanted them to do, does not mean that they are reviewable. It's a fact.
If they didn't probe at all?
Well, on the facts of this case, I wouldn't say they didn't probe at all.
There's no doubt about it that if you see, that's the problem. If you tell me, oh, there are other parts of the record in which they did, but the answer is there's no suggestion that that is so, with regard to all the points that we have made in the judgment. If you said, well, if you looked at the same page that you've relied on and you've made those mistakes, goodness, I wouldn't be asking you any of these questions.
If one looks at the replying affidavit, they do delve into some of the details of the. They do delve into some of the specific details.
Yeah, I read
that. And they do point to parts of their own report, but I would disagree fundamentally that this judge simply sat there, kept quiet, didn't ask even a single question, and then wrote a report and said we find nothing wrong here. There were other activities which they tell in their report how they went about this matter. They had evidence leaders, and they had all manner of machinery. It is a question of how they went about doing their duty. And I would submit that part is the fact-finding part we are doing, and that part is not reviewable. The report ultimately is for the consumption of the president. If he doesn't agree with them, he doesn't have to implement the reports. But it is not for the court to then nitpick and go into the report and say, we would have preferred if you had asked these questions and those questions. And we submit that there are prospects. That raises a very discrete issue about how far into the day-to-day running of a commission a court should get into. And we submit that there are prospects. It's an important matter which needs the attention of a
Thank you.
Court.
Do you have further submissions, Mr. Nalane?
If I may just...
You still have a lot of time, you know.
Yes.
7 minutes, I think.
Let me just find the judgment of in the latest court of Floppe, of JP Floppe. where
Is that the judgment? Sorry to get this right. The judgment of the 3 judges of the Gauteng bench who
yes,
gave leave to appeal. And the point you're making there, as I understand it, Mr. Mmolli, is that they say, it's a point one has to take account of. They say, well, then no, Judge Schlorpie has no case, but the fact of the matter is it's in interests of justice or public interest that the issue with regard to the impeachment of a judge should be dealt with by a higher court. I mean, it seems to me, I'm paraphrasing, but that's the thrust, is it not?
that's the thrust.
Yeah.
And we're then applying it to this case. We are living in an era where there are a lot of commissions of inquiry. One of them has just concluded, a mega one, which over the years, its findings are going to be scrutinized in this or that fashion. The mere fact that this court said, as right at the beginning, there is no ready-made jurisprudential tool in our jurisprudence to deal with a matter of this nature, that in itself just shows the novelty of the matter and the importance of the matter. And so that future commissions of inquiry, if yourself, JP, are asked to head a major commission of inquiry, how does one go about the mechanics of it? And as far as the legality part, where it's said the court can intervene on the basis of legality, we submit that the commission complied with the legal prescripts which it had to do. The Commissions Act says you have a commission of inquiry. It doesn't say how you must do it. You then have the regulations passed for this specific commission. It doesn't say how you must do it in any specific date. So, if you, as the commissioner, think that you will not attach any evidential value to the evidence of Dr. Young or whoever, it is you, but you are not exercising judicial functions which can then be scrutinized in a judicial case of review. This is not like the public protector case, which my learned friends have relied on, the Maiden Guardian. Public protector is a statutory body which delimited powers in terms of the Constitution and the founding legislation. Their function is to investigate malfeasance. This commission is an ad hoc commission, gather facts, make a recommendation to the president. The president might take them or might not take it.
But you are not suggesting, for example, that or are you? So let me get this right, so I understand your submission. Are you advancing the proposition that under no circumstances can a court such as ours review a commission of inquiry? Or are you suggesting that what you're really talking about is what the parameters of that review are?
The parameters, that's what we're talking about.
All right.
It cannot, the judgments which the court relied on, they raised 3 points on which a commission could be reviewed. One of which is if it did not give the parties rules of natural justice. Those are, for instance, if you issue a subpoena improperly, I mean, those are some of the things that could be reviewed. But as to the mechanics, who to call, who not to call, how many questions to ask them, either vigorously or non-vigorously, that is a terrain that must be left for the Commission of Inquiry to deal with. And the president will decide whether they acted reasonably or not. And not for a court to say, a reasonable commission of inquiry should have done this, it should have gone to Rome, it should have gone to Munich, or wherever.
I understand that. I just wanted to ask you this, because I perfectly understand what you're telling me. But I suppose what I want to ask is the following. Going back to the judgment, the Schlorpie judgment that you've relied on, I'm just troubled by the following. If we found that there were no prospects of success in this case, in other words, if we accepted, just for the purpose of a hypothetical debate between yourself and myself, that Mr. Budlender is correct. I'm not suggesting he is, I'm just putting it to you, obviously. Mr. Budlender is correct that, in fact, there are no prospects of success on the merits. Would you, how then does one give leave to appeal? In other words, can you simply say, oh, this is an interesting question that's troubling our country with commissions of inquiry, and we just jolly will give leave on that basis? Or do we at least have to satisfy ourselves that on the factual matrix of this case, there are some prospects of success, which coupled with the interests of justice get you over the line? Or can one say, we don't think there are any prospects of success at all, but nonetheless we should give leave?
Well, I would prefer the latter. But
yeah, I'm sure you would. But I'd like, but if you could help me here, I'd like that we write a judgment that people don't say, "Oh my goodness, that's Davis again." So please, help me here.
So our submission is that, as I read the judgment, it says, Shopper judgment says, we personally, because we have dealt with the matter, we have had the matter. We personally don't think there are prospects, but there are matters which go beyond JP Shopper, which are important for the public, which should be investigated. Parliament, the integrity of the judiciary, would say in this specific matter, it is not simply the interests of the two judges that are paramount. If this was a run-of-the-mill case where people are suing for medical negligence or damages, one could have adopted a different view. But here you have people who are performing overtly official duties, both as judges and as commissioners. And they do certain things which some people might not agree with, especially the respondents. So those are important matters. What is the scope of interference that a court should make? And this court has said, we don't have sufficient jurisprudence in our own court, and let's look elsewhere. So that is a matter which is important. It is not simply academic. Yes, it is tied to the fate of these two judges, but it raises matters of importance as well, just as in the matter of JP Shopper.
Thank you.
Yes, and if I may just read the one paragraph from the judgment, paragraph 6. Notwithstanding the view that we take of the lack of merits in the application, it is plain that the case has raised matters of significant public importance. The controversy embraces both the obvious and several nuanced issues of critical significance in the administration of justice. This includes the integrity of the judiciary as a whole and the norms by which it falls to be held accountable, and the proper functioning of the Judicial Service Commission.
What paragraph is that?
Paragraph 6.
Sorry?
6.
Paragraph 6.
Paragraph 6. Thank you.
And so would say that there are parallels with this case.
I think one other consideration, Advocate Nalane, is once you make justified submissions regarding your reliance on the Shopper judgment, what is different in our matter is those issues of public importance that were found to justify leave by the other bench are raised here when they could have been raised when the judgment went out, which is what happened in the Shopper matter. They are raised here simply because a complaint intervened. And then the two applicants then decided, oh, by the way, we didn't agree with this judgment in any way. There are issues of public interest here, and then try and raise all those issues. I think that's the issue regarding the preemption, which continues to worry me.
Would submit that the heading public interest would submit also implicates whether or not condonation should be granted.
Yes.
In the circumstances matter. So that would submit is also a matter of public interest where given the peculiarities of this matter about judges fired and they were doing judicial and duties as commissioners.
Yeah.
So that's our submission, that even the issue of conduct is a matter of public interest, which ought to be viewed from that lens.
Yeah.
as a front basis.
Your 1 hour is finished. Do you still have other submissions to make? I know we were asked a number of questions. If you need more time, you are free to tell, and we'll give it to you.
I think that should be, those are our submissions. Our heads are there.
Yes.
If I can improve on them orally, they are there to be read.
Okay. And you want costs, of course.
Well, if we are granted leave to appeal, say cost will be in the course.
I see. Thank you very much, Advocate Nalane. Advocate Badlander.
As the court pleases. My lords and my lady, I'm going to start by setting out the 7 core submissions which we're going to make, and then I'm going to go through each one of those in turn. Our core submissions are the following. The first one is that the applicants have no locus standi to appeal because they elected to abide the decision of this court. It's a slightly different point from preemption. They elected to abide the decision of the court, so they have no locus standi to appeal. Secondly, we say that their right of appeal has in any event been preempted because they elected not to appeal. The third core submission is that this application is hopelessly out of time and no basis, no proper case has been made for condemnation. The fourth core submission is that the applicants do not take issue with the core findings of this court, namely that they did not conduct a proper inquiry. Fifthly, the applicants rely on this court's failure to do something which the court was not required or even entitled to do, namely to trail through 32,000 pages of evidence, looking to see whether they, which were not before it. We haven't had much of that this morning, thankfully, but that's been the core complaint all along, that your lordships and your ladyship should have got all of that information and then read it. The sixth point, sixth core submission, that the test which your lordships and your ladyship applied, the test of an open and inquiring mind, has already been determined by the Supreme Court of Appeal and by the Constitutional Court. So the matter is settled now. It's no longer an issue. And the seventh core submission is that the last-ditch attempt to say, even if we have no prospects, even if our case is hopeless on the merits, give us...
Oh, sorry. I thought Advocate Nalane had vanished. He's still here. Sorry.
Okay.
Sorry.
No, I'm still here. I'm just saving on.
Good.
Thank
Good.
you.
I think he's having a smoke.
Sorry, Mr. Button, before you get on to a 7th point, I was writing the 4th one down and didn't write the 5th one down.
I'm
Can
sorry.
you just repeat that? No, it's
Yeah,
my fault. If you wouldn't just mind doing that so I can get it down.
Yes. The fifth point is that the applicants rely on the court's failure to trawl through 32,000 pages of record which were not before it.
Thank you.
The sixth point was that the court applied the test
Got that.
of an open inquiring mind. And the seventh point is that the applicants make a last-ditch attempt to say, even if our case is hopeless on the merits, give leave, because there's another compelling reason why the appeal should be heard, the Flope argument. And so we submit that for all of those, for each one of those reasons, this application should be dismissed. So I then turn, before I turn to the deal with each in turn, can I make two other points arising out of the submissions of my learned friend. Firstly, in relation to the complaint to the Judicial Conduct Committee, it's not correct that the complaint to the Judicial Conduct Committee alleges fraud or corruption on the part of the commissions. That's not so.
I understand it.
Secondly, in that regard, the complaint to the JCC will not go away if this court's decision is set aside. If, for example, if a higher court says this court wasn't entitled to investigate and consider how the commission was conducted, the complaint doesn't go away. The complaint of the complainants in that case, who are not incidentally the respondents in this case, stays, which is that the commission didn't do the job it had to do, and inexplicably didn't do it. They didn't carry out their functions in the manner required by the law. So, and finally, in response to my learned friend's submissions, the question, this court made no findings of judicial misconduct against the two judges concerned. That is a matter which obviously will have to be decided by the JCC. And of course, the JCC may be interested in what this court had to say about the matter. But in the end, the JCC and the JSC have to make their own decision and decide whether there's evidence of judicial misconduct. And that will be debated there in due course. Then if I can then go back now, cycle back to go to each of my 7 points in turn. The first point, I start by saying this is a truly strange application for leave to appeal. It has 7 strange features, which make this, I submit, it's certainly unlike any application for leave to appeal that I've ever heard of, and I submit that it, respectfully submit, it must be also the strangest application for leave to appeal that the members of this court have ever heard. The 7 strange features are the following. The first strange feature is that the applicants elected not to participate in the hearing in this court. They elected and they filed a notice saying we abide the decision of the court. And they also elected not to file a report explaining what they'd done and why they'd done it, and placing the matter before the information before the court. They elected not to file an explanatory affidavit, which we often see in cases such as this, explaining what they had done and why they did it. The president makes the affidavit on behalf of the president, the explanatory affidavit says, well, this is what the judges could have done, and they chose not to do so. And the judges don't answer that and say, no, we couldn't have done it, or no, we could have done it, but we chose not to do it for the following reasons. They are silent on that question. All they say is, we thought the judgment wasn't important. That's really what it comes down to. And so the failure to oppose or to file any report or affidavit speaks for itself. They declined, the judges declined, the respondents, applicants declined to participate in this case in any way. And we know what the consequence of that is. When a party declines to participate in the litigation and elects to abide the decision of the court, then it has no power, it has no locus standi to appeal. And that's the judgment of the SCA in the Cilliers case, which is referred to in our heads of argument. I'm not going to go there. To our heads of argument, paragraphs 39 to 42, where the SCA said a party has no locus standi to appeal in a judgment which it is elected to abide, where it's chosen not to participate. And the Constitutional Court has underlined this principle in the New Clicks case. We refer to the New Clicks case in our heads of argument at paragraph 44. And the court, not going to take the court there, the Constitutional Court said, ordinarily, where a party chooses not to participate, that's the end of it. It can't then appeal. So the first strange thing about this application is this is an application by people who elected to have nothing to do with the litigation, nothing at all to do with it. Now they say they want to appeal against the decision the court made. We say they have no locus standi. The second ground, second strange feature of this case is that the applicants acquiesced in the judgment of this court. They elected not to apply for leave to appeal, and they gave effect to that decision. Their attitude was, well, we chose not to challenge the decision of this court. To borrow an infamous phrase in our history, the judgment left them cold. They weren't interested in it. And so they chose not to appeal against it. And in the Zuma case, the Constitutional Court explained the consequences of this. Again, I'm not going to go there. It's in our heads, paragraph 37. We set out what the Constitutional Court said. You can't do that and then come along afterwards and say you want to appeal. The applicants in the phrase used in the judgments, they resigned themselves to the judgment. They elected not to seek leave to appeal against it, and the result is that their right to seek leave to appeal was preempted. And so that's the second strange thing about this application, that the applicants chose not to seek leave to appeal, and now they seek to do so because they belatedly realized that the shoe pinches or may pinch. But they can't now appeal because their right of appeal has been preempted. You can't blow hot and cold in one matter. That's the second reason. The third reason this is a strange application for leave to appeal is that it was filed more than 2 years after this court, or legal oddities and extreme cases. This must be it. I've never heard of one. Maybe your lordships or your ladyship have heard of one, but I've never heard of a case in which an application for leave to appeal is filed 2 years late and a court then grants leave to appeal. Where we refer in our heads of argument to a case called Settlers Agricultural High School. That's a case in which a school made applied for leave to appeal to the Constitutional Court 9 months after the SCA had refused leave to appeal. And the Constitutional Court said, sorry, it's just too late. 9 months is too late, even though there may be merits in your case. And even though the point is not it's quite an important one. This Constitutional Court said you can't sit in your hands for 9 months and then come and apply for leave to appeal. This is 2 years late, not 9 months late. The applicants ask for condonation, and we submit that the application is, with due respect, absolutely hopeless, and we address that in our heads of argument. Again, I'm not going to go there. It's in paragraph 13 of our heads of argument. The trigger date can't be the date when they thought of something new. The trigger date can't be the date when they said, oops, we now see that this judgment has consequences, or might have consequences for us. The trigger date is when the judgment was given. But even if the trigger date is when they realized, when they woke up and said, oh, this isn't bad for us, even then, it was 4 months late. It took 4 months from the date when they knew of the JCC complaints to the date when they filed the application for leave to appeal. They say, one of the reasons they give, they say they had to read the voluminous judicial conduct complaint, which was 53 pages long. I mean, really. So they had to consult counsel. Yes, counsel don't take 4 months to deal with this. So we refer what was said in this case. We refer to our heads of argument, paragraph 13, and to the cases referred to there. We say, so that's the third reason why the application for leave, why this is a strange application for leave to appeal. It's a record, judicial record, or not judicial record, jurisprudential record 2 years late. And we, with respect, adopt what was the proposition that was put to our learned friend during his submissions this morning, which is that there's no public interest in this application for condonation. The sole ground on which it's made is that it's bad for the two respondents, the two applicants. That's the sole reason which is given. That's why they came late. They don't, and that can't found an application for condonation. Then the fourth reason why we say that this is a very strange application is that when you read the papers, you see that the applicants don't actually take issue with the essential finding of this court, which is that the commission didn't conduct a proper inquiry. There's no issue raised in that regard. The applicants do not claim, for example, that they tested the evidence of Mr. Sheikh, Mr. Chippy Sheikh. They don't dispute that Mr. Chippy Sheikh was a very important witness. They don't claim that they tested his evidence, and they don't claim that they didn't have to. There's no allegation, there's no assertion by them anywhere saying, oh, well, as to Mr. Sheikh, we didn't need to ask him any questions, and this is why. Your court will remember the only question they put to Mr. Sheikh was, in essence, are all these complaints against you untrue? And Mr. Sheikh, surprise, surprise, said, yes, indeed, they're untrue. So there's no, as far as Mr. Sheikh, a very important, no denial. They don't dispute that he was very important. They don't claim that they didn't need to test his evidence, and they don't allege that they did test his evidence. Mr. Hlongwana, they don't claim that they tested the evidence of Mr. Hlongwana. They don't dispute that he was a very important witness, and they don't claim that they didn't need to test his evidence. Not raised. There's no dispute about that. They don't claim.
Mr. Butler,
yes.
Sorry to disturb you. Your 15 minutes is up, and it happens to coincide with our constitutional right to a tea break, and we're going to be taking it now. When we come back, the court will then start putting questions to you. I've just noticed that the settler's judgment that you referred to, I looked for it, I couldn't find it on Safely. I think your nimble-fingered junior could upload it onto this case bundle on case lines, just like the applicants did. I think the applicants have uploaded all their cases onto the case lines bundle. Could we then take 15 minutes? We'll come back at, let's just check the time. It's 11:17. What's 15 minutes from there? It's 11:33. We'll come back at 11:35. Thank you. Court adjourns. It's 11:34 going on to 11:35, but seeing that we're all here, I think we should continue. Advocate Butlander.
Thank you, Lord. Lord, we have put the Settlers Agricultural High School case on case lines, and it's on the screen as well now, but I'm not going to go there, so it would be helpful if that could be removed from the screen, I think.
Yeah.
Some clever person can do that. Thank you.
Yes, that's good.
I was wondering who was sharing their screen, but anyway.
No, I have some very talented people on our team who do things that I certainly can't do.
The Butlander, I think as you start, what I would like you to help me with is how do you get around the two cases? One is the Supreme Court of Appeal case, that is the Minister of Defense and others with the South African National Defence Force Union by the SCA, and the other one by the Constitutional Court, the South African Revenue Service versus CCMA and others, which took the policy around preemption head on and said, where the interests of justice require it, preemption shouldn't close the door of justice on the litigant. I'm asking you to deal with this in the light of what the applicants are saying about them as judges in their personal interest, but other judges as well who are appointed to head commissions of inquiry. And the argument is the interests of justice are that they should be given leave here for higher courts to also have a say on whether this court was correct in saying it could review and set aside the entire report of a commission of inquiry, whether on a limited basis or on any other basis. So I'm just asking you to deal with that, if you don't mind.
Thank you, Justice Malambo. There are two things to say about that. This is a matter which relates to the sixth reason why we say this is a strange application, and I'll deal with it now. We, of course, accept the authority of the SCA and the Constitutional Court that preemption is not an absolute bar, that there will be cases where the interests of justice require a court to exercise its discretion to say, well, notwithstanding preemption, we can go ahead. But there are two, the essence of the answer to it is twofold. Firstly, there are no interests of justice which bear on this matter. This is a case about the interests of the two applicants. Secondly, to the extent that the claim is made that this will be helpful to other courts which have to deal with reviews of other commissions one day, maybe, we make the following submission. It's important to distinguish between a review and setting aside of the commission on the basis that it didn't do the job.
Yeah. And
a review seeking to set aside its decision on the basis that it was badly wrong on the merits. When it comes to the question of the merits, if, for example, the commission we find A, B, and C happened, and an objector wants to say, well, that finding must be set aside because it's so unreasonable that no reasonable commission could have found it. In other words, a challenge to the merits of the finding, then then there would be interesting questions about what is the standard of reasonableness when one's dealing with a commission of inquiry. Is it the same standard as one dealing with other administrative bodies, or is it different? Is it different when there are judges involved? There would be interesting questions if this was a case about whether the findings were reviewable on the merits, a merits review. But that's not what this court did. This court was very careful not to go into the merits of the findings. The court said you didn't do your job. The process that you followed was impermissible because you didn't conduct an inquiry. And so this is not the interesting case which may one day arise in another court, in another case, where an allegation is made that the findings of the commission were unreasonable. And there must then be a test as to what is it, a rationality test, a reasonableness test, etc., etc., etc. This is purely about whether they did their job in the manner which the court, which the law requires. And on that, there is no room for any debate at all as to what the test is. If they go to the Supreme Court of Appeal, the Supreme Court of Appeal will say, we already decided that. We decided that in the Mail and Guardian case. We decided that where there is a statutory body which has a task of investigating and making a report, it must do the job with an open and inquiring mind. It must search for the truth. And if it doesn't do that, it doesn't do its job lawfully, and its findings fall to be set aside. That's so when if they arrive in the SCA is going to say, what are you talking about? We've already decided this matter in the Mail and Guardian case as to what the test is. If they go to the Constitutional Court, the Constitutional Court will say the same, because since this court gave its judgment, the Constitutional Court upheld the test applied by the SCA in the Mail and Guardian case. It's not referred to in our heads of argument. Can I give the court the reference? And we'll upload it as well. The case is Public Protector versus President of the Republic of South Africa. And the reference is in the SA Law Reports is 2021, Volume 6, SA 37, Constitutional Court. And this is what the court, I'll read what the court said, 3 paragraphs. The Constitutional Court said, the question which, this was also a case about the Public Protector, of course. The question which the Public Protector's report does not address is how the divergence between the managers and the emails was resolved. That's a divergence of evidence. It appears that the Public Protector simply chose the emails over the manager's oral testimony, which she disregarded. This was inconsistent with the principles laid down by the Supreme Court of Appeal in Mail and Guardian, the decision to which the report refers. That decision affirms that the objective of investigations by the Public Protector is to discover the truth. I kind of interrupt myself and say that is exactly what the function of a commission of inquiry is, namely to discover the truth. To continue with the quote, where the investigation yields disparate pieces of evidence which do not fit into place, the Public Protector must continue digging until the true picture emerges. As Nugent J.A. observed in that case, quote, the Public Protector has no place summarily dismissing any information. His or her function is to weigh the importance or otherwise of the information, and if appropriate, take steps that are necessary to determine its truth. Paragraph 77 of the judgment of the Constitutional Court. Mail and Guardian makes plain that the duty of the Public Protector is not only to discover the truth, but also to inspire public confidence that in each investigation the truth has been discovered. Where the evidence is inconclusive or diverges, the Public Protector is obliged to carefully evaluate it to determine the truth. At the end, she must be in a position to say that the truth has been revealed. And paragraph 139, while the Public Protector has the leeway to determine the form to be followed in a particular investigation, her investigation must meet the basic benchmark of a proper investigation that is conducted with an, quote, an open and inquiring mind, close quote. In Mail and Guardian, the Supreme Court of Appeal defined the standard. So the test of an open and inquiring mind for a statutory inquiry has now been set by the SCA in the Mail and Guardian, and has been confirmed by the Constitutional Court in the matter to which I've referred, Public Protector versus the President. A commission, of course, is a different statutory body from a public protector, but its core function is the same. It's to carry out an investigation and to establish the facts and the truth. And the two highest courts in our country have now said that the benchmark of what is required for a proper investigation is that you must have conducted with an open and inquiring mind. Now, what this court said in this judgment in this case is that the applicants didn't conduct it with an open and inquiring mind, and that's the beginning and the end of the case. So it's not a case, Justice Mlambo, where there's a public interest in having a determination of what is the standard of reasonableness, or to what extent can findings of fact be set aside. This case is a case about what a commission has to do in order to act lawfully, namely conduct with an open and inquiring mind. That's the test which is settled law now in South Africa, and your lordships and your ladyship found that this commission did not conduct it with an open and inquiring mind. And I was taking your lordships through examples of that. But there's actually no dispute.
Can I just ask
about that,
the Budlender? I don't want to interrupt the train of questions my colleague, Judge President Malamba, but are you saying effectively, look, if you want to give leave, because there's a major principle out there, that is the principle that doing your job, if I could use the colloquialism, isn't a ground for review, no higher court is going to actually sanction that, because the public protector, particularly in the affirmation of Mail and Guardian in para 139, make it absolutely clear that that is the case. And it'd be hard to argue that the approach taken in relation to the public protector would be different to a commission, the inquiry sourced in the Commissions Act. Are you saying that, well, that only leaves the question of whether we got it right with regard to the application of the test rather than the test itself, which is a separate inquiry? That's absolutely so, Justice Davis. And it's not only hard to argue that the test would be different for a commission than from a public inquiry, than a public protector. It's impossible to argue it. And that's why learned friends haven't attempted. Investigation is an investigation, quite correctly, haven't attempted to say, oh, well, what the public protector has to do is different from what a commission has to do. A commission, they haven't had the gumption to make the submission, nor could they make the submission, that a commission doesn't have to do the job with an open and inquiring mind. It would be impossible to make that submission, and so they don't make it. And so we say that it's purely, as Justice Davis, as you put it, it's a question of the application of the test. And what I was showing, or seeking to show the court as I was going through my fourth reason, was that it's not in dispute, actually, that they didn't conduct it with an open inquiring mind. And I referred to what was done with Mr. Sheikh, or not done. I referred to Mr. Hlongwane. One can go to the same next thing. The Debevoise and Plimpton report throws up a host of questions about apparent malfeasance in the process. The commission didn't deal with that. The suggestion from Mr. Nalani, as I understand it, and he's welcome to correct me if I've got him wrong in his reply, is that, oh, well, but that's true on one hand, but on the other hand, if one read the 32,000 pages, one may well find reasons which are entirely different, and that therefore another court could come to a different conclusion on those facts. Well, if that were the case, there are two answers to that. Firstly, the notion that your lordships and your ladyship had to say, we've only got a record of 700 or 800 pages. We're very unhappy about that. We want you to give us all the oral evidence that was given. And it wouldn't be just the transcripts, of course. It would have to be all the documents that were placed before the commission. Because it's not only oral evidence that they considered, and it's 32,000 pages, apparently. And the only way you can get there is by saying this court has a duty, which has never been imposed on any review court that I've ever heard of before, that it must go beyond the record which has been placed before it. It must go say, I want another 31,000 pages because I want to look through it to see if I can find anything there which supports what the commission has done.
with respect, that's a risible proposition. And so if the applicants had said in their founding affidavit, look, there's a lot of evidence. Let me give you a couple of examples. This is what actually happened with Mr. Hlongwane. For some reason, the applicant's Corruption Watch ignored pages 3,100 to 3,200 of the record. There it is. Look at it for yourself. That would be different. But they don't do that. They don't do that. They don't actually dispute that they didn't question Mr. Hlongwane or Mr. Shape. Nor did they look into the Debevoise and Printon report. The Debevoise and Printon report, they took the most peculiar attitude. They decided wrongly that it was privileged and couldn't be looked at. They then said, we're going to look at it anyway. We looked at it anyway, and we saw nothing in it, which was interesting. Well, that's the most astonishing proposition in the light of the evidence which was before your lordships and your ladyship. So they also don't claim that they didn't need to explore the differences between the draft Auditor General report and the final report. They don't claim that they explored it, and they don't claim that they didn't need to explore it. They don't claim that they didn't need to take account of the proceedings in the Sheikh case, and they don't dispute the core finding of this court that the evidence reveals, quote, a manifest set of errors of law on their part, close quote. That's what this court found. They don't say that this was wrong. So on what possible basis can there be an appeal on the merits? Any merits in an appeal? One could go on and on. Your lordships and your ladyship will remember that when you came to write the judgment, you didn't traverse every one of those omissions which we alleged in our long heads of argument. You took out the top 12, if I can call it like that, something like that, and you said, well, here are examples. But the court will remember that there were pages and pages and pages of evidence that on the record that they didn't do the job. And the applicants do not challenge, we submit the fundamental finding of this court that they didn't conduct a proper inquiry. And that being so, it's difficult to see on what possible basis there can be an application for leave to appeal.
Well, Mr. Butlander, on a different issue, and I mean, the judgment of the court of quo, or our judgment, let me put it that way, is firmly premised on legality
Yes.
as to why we reversed or set aside the commission report. Now, the applicants argue in this application that in doing so, we conflated rationality with legality. What's your response to that?
Well, it doesn't really matter with respect, Justice Mlambo. It was both rationality and legality. It was legality because they had a legal duty to do certain things and they didn't do it. So that's a legality review.
Yeah.
It's a rationality review because on the basis of the Albert decision in the Constitutional Court, when you have a power, you must exercise it in a manner which is related to the purpose of the power.
Yeah.
You can't, and if you don't do so, then your process is irrational, liable to be set aside on that ground. You can't have a power to do X and use a process which can only achieve Y, which can't achieve X, which is what was done in here. They had a power which was to find out the truth, and then they used a method which couldn't possibly reveal the truth because they didn't test the evidence before then. And so it's both irrational and fails at the test of legality. And yeah, it doesn't matter which, it's both. We submit. Then, Lords and the Lady, I've dealt already with the fifth reason which I'd refer to, which is the record. The complaint about the record surfaces and disappears and surfaces. In the original complaint, the members of the court will remember, was the court should have had regard to all of the oral evidence which was placed before the commission. Then in the papers in this court, it mutated to saying, no, you should only have had regard, you didn't have regard to the whole of the written report, but the whole of the written report was in fact before you. But then it mutated back again to you should have had regard to the oral evidence. If you had to have, say again, if you had to have regard to the oral evidence, you had to call for everything which was before the commission, which no one had placed before you. And we know how Rule 53 works. Rule 53 works on this basis that a record is produced, and then the parties choose the parts of the record on which they're going to rely, and they place that before the court, and that becomes part of the court record. And it's not part of the function of a court to resubmit to say, well, I want to see another 31,000 pages just in case. So that was the fifth reason. The sixth reason I've now dealt with, which was that the principle has been settled. It's been settled in the Mail and Guardian case, and it's been approved by the Constitutional Court. And with respect, Mr. Justice Davis is correct that the complaint really is not about the test. The complaint is about the application of the test on the facts.
Can I ask, sorry, Mr. Budlender, to interrupt you again. As I said to Mr. Mmolli, I apologize. It's hard in this medium. It seemed to me that a point pressed by Mr. Mmolli was, if you look at a full bench of this division in the Schloppi case, the court came to a not dissimilar conclusion that there were no real prospects of success in relation to the complaint. Again, paraphrasing, it seemed to me that what the court was saying was, well, all those arguments with regard to whether in fact there was gross misconduct are, well, we don't think there's any merit in them. However, because this is an impeachment of a judge and it's so important it should go to a higher court, Mr. Mmolli was saying, by basically parity of reasoning, this is so important that it should go to a higher court notwithstanding. Now, I mean, we're not bound by them, although I suppose it's a pretty, you don't just reject what your brothers and sisters have to say. So I'm just interested whether that's correct, or alternatively, is it is this different? And I ask that question because you seem to be pressing the point that in this particular case, it can't possibly be about a principle because the principle is already there. Mail and Guardian, Public Protector, it's about the application of principle. And does that put it in a different league to the Schloppi judgment? That's my real question, I suppose.
Yes, I think Justice Davis, one has to start first by reading what the full bench in the Schloppi case decided.
Yes, I'm just.
And can I go there?
Yes.
It's paragraph. It's on the case lines. It's 3.14-4, and it's paragraph 6 of the judgment.
Right. Carry on.
And this is what I'm going to read 2 paragraphs of what the full bench decided, because this is really, with respect to our learned friend's, best shot at leave to appeal, and it's not a good shot. Paragraph 6 says, notwithstanding the view that we take of the lack of merits in this application, it is plain that the case has raised matters of significant public importance. The controversy embraces both the obvious and several nuanced issues of critical significance to the administration of justice. These include the integrity of the judiciary as a whole, and the norms by which it falls to be held accountable, and the proper functioning of the Judicial Service Commission. Indeed, the matter also has implications for the parliamentary process. These aspects of the case go beyond the personal predicament of Schloppi JP and the merits or demerits of his personal case. Paragraph 7. The disciplining of a judge of the High Court for impugning a court's integrity is unprecedented. The removal of a judge of the High Court by the National Assembly upon a finding of gross misconduct by the Judicial Service Commission is unprecedented. Moreover, although the machinery of the judicial process of the JSC has previously been the subject of judicial scrutiny, the peculiar issues of law raised in this case regarding the composition of the Judicial Service Council, the effect thereon on the validity of its decisions, which implicate the proper interpretation of sections 165, 177, and 178 of the Constitution, have not previously been examined by a court. In our view, the case raises discrete issues of public importance that will have an effect on future matters. Now, if you go, the full bench listed about 8 matters, I think I counted, which were of fundamental importance for the judiciary and the JSC and our system of government going forward. Not one of those is implicated in this case. Not one. The only issue which is implicated in this case, they may of course become relevant, some of them may become relevant in the JCC and whatever follows from the JCC in due course. But in this case, this is not a case about the integrity of the judiciary as a whole. It's not a case about the norms by which it's held accountable. It's not a case about the proper functioning of the JSC. It's not a case about the disciplining of a judge of the High Court. It's not a case about the removal of a judge of the High Court by the Assembly on a finding of gross misconduct, etc., etc. None of those things arise. So what is the issue of public importance which is raised in this case? Well, I say two things about this.
It can only be, and I'm speaking sort of the top of my head, I suppose, it can only be presumably the power of a court to review a commission of inquiry. And then, as I also speaking on the basis of your submission to me, I've then got to answer in my head, well, you know, haven't they done that already by extension of the public protector case and the Mail and Guardian case, which is, I think,
Yes.
what you could probably tell me.
That's right. It's already been decided. And in fact, if you tried to argue this case before the Constitutional Court, what the court would say, as they said to me rather rudely in a case which I argued, you're just arguing about facts. You're not arguing about a legal principle here or constitutional principle. You're saying that the SCA got the facts wrong. We don't deal with that. That's not our business. And what they would be saying is, your lordships and your ladyship got the facts wrong. And the Constitutional Court would say, we don't deal with that. That's not our business. So there is no constitutional principle which is implicated. And there are none of these very high-level, fundamental questions about the nature of the judiciary and accountability of the judiciary, which were raised in the public in the Hlophe case. This is, I don't want to underestimate the significance of this case. It is an important case because it's an unusual case in the sense of it was a commission comprised of judges who are being reviewed. But the principles with respect are bog standard. It's that you have to act, you have to do what the law requires, you have to conduct an inquiry with an open inquiring mind. That's the only principle, and that principle has been determined already by the SCA and then by the Constitutional Court. So as we say, make the submission that although the setting of this case is unusual, the principle involved is not an unusual principle. It's something which courts do every day. Courts of appeal set aside decisions of other judges. Courts of review set aside decisions of statutory bodies. They do it and they ask themselves, did they do the job? Did they get it right? Did they do the job they were supposed to do? And when they find that the court or the statutory body didn't do the job they were supposed to do, they say, we set it aside on the grounds of legality or rationality. And there's no high principle involved in that. And there's nothing special about this case in that sense. And so that's our seventh point of why this application must fail, that the rather desperate last-minute reliance on the Hlophe case. I don't mean to be offensive, but the case was only decided recently. But the attempt to rely on the Hlophe case to say, well, even if our merits are hopeless, we still should get leave to appeal because of the high points of principle which are raised in the case, can't survive because there is no high point of principle which is raised in this case, which has not already been decided by the SCA and the Constitutional Court.
Yes,
And,
okay. Can I ask you on a different issue also? You say the complaint at the JCC does not allege corruption or fraud. But is there an allegation in that case about gross misconduct or the complaint there? Is it related to what happened in this case?
Justice Liu, it's the complaint is that the conduct of the members of the commission in sitting on a 2 or 3 year commission without asking the fundamental questions, without doing so with an open inquiring mind, is gross misconduct. That's the failure which is alleged. And the Chief Justice, or the acting Chief Justice as he then was, referred that matter to the Judicial Conduct Commission. So it's that is the complaint that is laid. Of course, I wouldn't. It would be facile for me to say that one doesn't wonder if the complaint is correct in that regard. One has to wonder how this happened. Why did it happen? But there's no complaint of corruption and fraud that I can ever recall. I think the complainants have been quite careful in that regard. Is
it your submission then that that complaint has no relevance to the present application?
That is so, Justice Liu. The question is whether the conduct of the two respondents, the question before the JCC is whether the conduct of the two applicants constituted gross misconduct. That's not a matter which was before this court and is not before this court. And when they decide the matter, they will no doubt have regard to all of the evidence which is available. They may also be interested in the judgment of this court, I don't know. But they will have to have regard to the evidence which is available to make a finding on whether there's been gross misconduct. And that's not a matter which this court was asked to decide, and it's not a matter which this court has decided.
Yes, thank you.
In other words, what would happen would be that whatever might have been found by this court would have to be properly laid before the Judicial Conduct Committee de novo, and they've got to make their own mind. Whatever we say is actually completely irrelevant to that.
That's right.
In the sense that I accept that, I have to accept, surely, that the trigger may well have been our judgment, but I don't even know. I assume that was the case. But your submission is that doesn't matter because it's got to be trawled through all over again. Yes,
they will have to. The JCC will have to be persuaded that the two applicants are guilty of gross misconduct.
They may have to read all 35,000 pages.
They may have to read 35,000 pages. The judges may have to give evidence and be asked to answer some questions. Yeah. What did you do? What did you do about Advocate Hlongwana? Why didn't you ask him anything? They may have to explain themselves. Those are questions which didn't arise here because you weren't concerned with why they didn't answer those questions. You found they didn't ask questions, and we can see that the questions are relevant. And so they didn't do their job. The question of why they didn't ask them was not a matter before your lordships and your ladyship, and nor should it have been. So it's a different inquiry, and of course one can't pretend that there isn't an overlap between what this court did and what the JCC will do.
Yeah.
But the JCC will conduct a different inquiry for a different purpose, not the inquiry which this court conducted, which will determine the legality and the rationality of the conduct of the commission, not the merits of its findings, just the way it conducted itself. Didn't do so with an open and inquiring mind. And it's really, with respect, impossible to argue that it did so with an open and inquiring mind. So those subject to the questions which the members of the court may have, those are our submissions. We submit that on each one of the 7 grounds to which I've referred, any one of those alone would be sufficient to say that this application for leave to appeal can't succeed. It's fatally flawed. And we ask that the application be dismissed with costs, including the costs of 2 counsel.
Thank you, Advocate Bartlander. Advocate Nalane?
Thank you, JP.
You don't need more than 15 minutes, do you?
No. If I do, I might ask for an indulgence, but I don't anticipate that I will need 15 minutes.
Yeah.
The point to start to propose is with the Mail and Guardian judgment. As I understand it, that judgment has closed the door to the applicants to argue any point relating to what they should or should not have done. And that is an open and shut case. The inquiry is simply, did you do what you had to do? If you didn't do it in terms of what the Mail and Guardian judgment says you must have done, then you didn't do an investigation at all. You didn't ask some questions, therefore you didn't investigate, in spite of a 700-odd page document which shows exactly who you interviewed, who told you what, and what the view you take of what those people have to say. Mail and Guardian had to do with the public protector. And to us, that's a distinguishing factor. And
well,
one cannot...
Can I ask you that? I mean, just 2 questions on that. Sorry to interrupt you.
Yes.
The first is, Mr. Bunda submits that the test for investigation is as articulated in both those judgments. Is your point being, well, that may be so, would you accept that? And then the second question is, why would it be not applicable to a commission?
The first question, so the submission we're making is that the test which was laid out in that judgment related to a public protector. It didn't have to do with the Commission of Inquiry at all. And secondly, the public protector's powers are far-ranging and wide. At paragraph 6 of that judgment, the court summarizes what the powers of the public protector are. One of it is to take appropriate remedial action. And we now know that remedial action is binding unless set aside. A commission of inquiry does not have to make any remedial action. So that is a fundamental distinction between a commission of inquiry and the public protector. The public protector is governed by both the Constitution and a statute, which tells what precisely the protector can do or can't do. And so that's a very, 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 very fundamental distinction. A commission of inquiry is governed by its terms of reference, primarily. And the court in this matter summarized the terms of reference right at the beginning of the judgment at paragraph 1. And one of the fundamental points is that the commission shall inquire into, make findings, report on, and make recommendations concerning the following, etc., etc. One should not be had to be saying, well, a commission can do as it pleases. But if you invoke the legality principle, as I understand, you got to say, did they follow the prescripts of what they were required in law to do? The law, as in our submission, the Commissions Act, the terms of reference do not say prescribe to the commission how it must make the inquiries, how it must inquire, and how it must do it. So
I accept that, but sorry to interrupt you, Mr. Mmolli, but can we just read together? I just wanted to read to you, and because it's relevant to what your submission is now. Paragraphs 1, 3, 9 of the public protector judgment. It says, while the public protector has the leeway to determine the form to be followed in a particular investigation, her investigation must meet the basic benchmarks of a proper investigation that is conducted with an open and inquiring mind. It then goes on to quote the Mail and Guardian judgment, which Mr. Budlander referred, and the passage here says, I think it's necessary to say something of what I mean by an open and inquiring mind. The state of mind is one that is open to all possibilities and reflects upon whether the truth has been told. It is not one that is unduly suspicious, but it's also not one that is unduly believing, etc., etc. Now, why they describing there the scope of an investigation, true about the public protector, but they're talking about an investigation. Surely a statutory mandate to a commission of inquiry pursuant to the Commissions Act has to conduct an investigation. Why would the principles of that investigation be any different to that which they've described in the passages I've read to you? But are you suggesting that an investigation by a commission doesn't have to be with an open, inquiring mind?
I think the point we're making is simply that one cannot transport holus bolus, the principles and the dictates which a public protector has to comply with, and say all of them, in all their shiny armor, must be transported onto a commission of inquiry. A commission of inquiry is a different animal altogether. It might not overlook this or overlook that. So while I'm not saying that a commission of inquiry can simply, sit at home and do nothing, but the standards which it must be held are different from that of a public protector.
I accept that. I suppose what I'm asking you, I'm sorry again to interrupt. I'm asking you, do you accept that a commission of inquiry must conduct an investigation with an open and inquiring mind, as they laid out here?
Indeed. And
Now,
we say,
if that is the case, why would any court not say, oh, well, we've set that out already, which is what Mr. Budender was suggesting. We've set that out already, and that is the test we must apply. Then admittedly, of course, the second question arises, well, factually, this court, the three of us, didn't apply that test properly. But that's the second question.
So we stay with our argument that it's not a commission of inquiry. The commission of inquiry, and now the question now is, how far must a court go in inquiring into an inquiry, whether they've done their job or not? The court says of this matter, but well, you didn't ask questions vigorously. Now, is that how far a court should go in inquiring whether or not a commission of inquiry was investigating and making recommendations with an open mind? There are no set rules to which if the commission does not comply, you then simply run a red pen across the entire commission report. And so we submit that there are differences. If an appeal court is seized with reviewing a commission of inquiry, is different. This court has acknowledged that there is a dearth of authority and that it had to go elsewhere to find for the jurisprudence. We submit that this point has there are merits to it. Now, my other friend says it is not in dispute that the applicants do not dispute that they accept they didn't do anything. They were there supine, and that is a matter of fact which must be accepted. The applicants say in their, firstly, in their founding affidavit, they deal with each and every one of the topics which the respondents picked to show that they didn't do their work at all. And I think I'll submit that it would be to be stretched too far to say they didn't do their work at all. One might criticize them here and there, but to say they didn't do anything at all would be taking the matters too far. They deal with each of those topics about Richard Young. They deal with Mr. Chippy Sheikh and Advocate Fana from one. Granted, they do that cryptically because it's a founding affidavit. They don't have to go chapter and verse. But the point of the matter, what they are saying is that they did not sit supine. And they say in paragraph 63 at 3.2-15, and I will read the last part only. The transcripts of the evidence of those witnesses are also available, but the court did not have regard to the evidence of those witnesses as contained in the commission report and simply relied on a few extracts from the report relied on by the applicants in the review application. Which brings us to the next point about the submission by our friend is the court simply had to look at what was placed before it and accept that and do not have to have regard to other parts of the relevant record. And I do not understand that principle to mean that one reviewing a decision with a record would simply confine themselves strictly and without any further ado to what the applicant says is their case. And while I accept that, yes, it might not be necessary to look at each and every scrap of evidence, but also one can say that you can look broadly at the record and come to a different conclusion. So I would say it is not common cost. The applicants don't accept that they did nothing about Mr. Fangwani, about Mr. Young, about Chippy Sheikh, and Zuleika Mohammed. They say we did go into the inquiry with an inquiring open mind. And I would submit that one looks at an entire, even the report itself will show that to submit that they had an inquiry mind. And so we'll submit.
I'll ask you one final question for my part. Would you agree? Well, sorry. What is your response to Mr. Budlender's point that nowhere in the papers before us on application for leave to appeal do your clients take issue with the way we read those exchanges of evidence? In other words, again, paraphrasing him, his argument was, well, if you said, but if you read 5 lines further, you'd have seen precisely that X was asked or Y was asked. Do you accept that there's been no issue taken with the way in which this court read that evidence and came to its conclusion? And if so, where do you say that?
I've read the line where they say that the court did not take into it might not encapsulate everything, but if one looks at the reply does point to specific parts of the
Yeah, I read that, but I still didn't see where, it's the sort of thing that a judge reads and you say, oh my gosh, I should put that in. And I didn't. That's what I'm saying. Where was that?
Well, I think all I can say is under every topic, they might not deal with whether 2 or 3 questions were asked, but all they are saying is in broad outline. They say we did our job to the best of our ability as far as Chippy Sheikh and Hlongwane is concerned. That's their view, and that's why they're a fact-finding commission. And the court might differ with them. They did their job in terms of the terms of reference into the Commissions Act. And the court cannot then say, well, a rational or a reasonable commission of inquiry would have asked 4 or 5 more questions or should have pressed harder. It's the view of the court. But that would submit is not a standard which should be applied in a commission of inquiry to review and set aside the entire commission report, some of which dealt with job creation, some of which dealt with the rationale for the rationale. Why did the government conceive of this strategic procurement exercise? And so we'll submit.
You do accept that we took 12 separate issues and canvassed them?
Indeed, but what the complaint by the applicants is that the court seemed, and maybe you can criticize the court here and there, but the court.
Yeah. Carry on.
Yeah. So the court took into account what Mr. Budlender said to them. Said, "This is the point. This is where we're going," and then all the applicants are saying is that there's more to the proceedings, and that's why they're saying if granted leave, they may have to apply for leave to apply for the admission of additional evidence, which would be in the form of the material which they had in front of them, and which will submit, they exercise their discretion and cannot be reviewed on the standard which is being used. And then another point is about the complaint, whether the complaint involves criminality. Yes, this is what the complaints are saying. And we've quoted this at footnote 4 at page 397 of our heads of argument. And what they're saying is that there are clear and worrying signs that Judges Seriti and Musi may have been party to criminal conduct. That is in the complaint. So I just thought I should set the record straight.
Is that in the actual complaint? Is that in the text of the complaint?
In the complaint itself.
No.
Yes, page 51 of it's under the relief sought.
Yeah.
All right.
And they say, in addition, the actions of Judges Seriti and Musi may amount to criminal conduct, especially in relation to the light utility helicopter and BAS systems matters as described above, and which the available evidence indicates that the Commission's final report materially misled the public regarding the content of vital interactions between the Commission and third parties. So there is imputation of criminal conduct, which is which is a very serious matter. And
Accept that. In any event, it's a serious matter when you get reported for gross misconduct. I accept that too.
yes. So those are the. Let me check. How much time do I have still left? JP?
You are on to extra time now, Advocate Mmolli.
Referee's time now. The referee's time.
Referee's optional time. So would submit that the applicants have now case, and they should be granted leave to appeal costs in the course.
See. No, thank you very much, Advocate Nalane, and thank you very much, Advocate Badlander. We will reserve judgment. We hope not to take too long to come up with our decision in this matter, and your respective instructing attorneys will be advised accordingly when the judgment is ready to be handed down. Thank you very much. This brings to an end these proceedings, and the court adjourns. Thank you.
As the court pleases.